Hi student, continues. Last lecture, company law definition, and definitely speaking about the general elements of the company law, consent, object, and the cause. And we are talking specific elements of the company contract, multiple members, presentation of contribution, sharing profit and loss, finally, avocat société. Now we are talking the formal elements of the company contract. Company contract, to be valid, it should writing and publication. Publication, very, very essential element of the company contract because to use the evidence of the company contract. And as Egyptian legislator confirm this is element at Article 507 of Civil Code. Stipulated the company contract should be in writing, otherwise it's void. Now, the effect as to the company. If the elements, general elements, specific and formal company formation, this is contract, is created a new person called juristic person. Now we are talking a legal personality of company contract, like name, patrimony, domicile, nationality. When we finish formation of the company contract, whatever civil company and the commercial company have legal personality and create a new person called juristic person. Legal personality established from the date of forming the company. Second effect of the formation of the company contract, the patrimony. Patrimony, it means consists of the assets and property of the company and also consists of the contribution of the partners to the capital and any money or property acquired by the company during its life. Third effect of the making company contract, the domicile of the company. Domicile, it means a place or locations or the place making or working the company. A person may have more than one domicile at the same time, as he may none. And also, like natural person have nationality and also the same characteristics of legal personality or juristic person. Nationality is the legal relation between the person and a definite state, the non-existence of the relation, the person. Nationality of the company is related the acquiring of legal personality. Okay, and this is nationality if happen any disputes between another company or which law applicable or which law choose is applicable if happen any disputes. In this case, if a domicile very, very important between the partners or between the legal personnel. Now we are talking nullity of the company contract. We are talking about the general, specific, and the formal elements of any company. If any of the substantive or formal elements of the company doesn't exist, the contract in this case is considered null. Null means no result from this contract is out. Null, it could be absolute, relative, or specific. Applying the retroactive principle of the nullity of company contracts may be result in the destabilization of the legal relations. Again, if making this is null in the past, you're making some troubles between the partners with third party. Types of nullity: relative, absolute, specific. A relative, if happen, the consent between the parties have mistake, fraud, and coercion. In this case, the member whose consent was vitiated had the right to sue for the nullity to the contract. And that this partner can request the termination of the contract with regard to all members. In other side of the capital company, the voidness of the contract visa one member doesn't affect the other members. The same applies in case incapacity of the company. Second nullity, absolute nullity. Absolute nullity happens if the company contract is illegal and opposes public order and morality, or this is contract like drugs, like weapons, like that. Third, specific nullity. When contract company is not concluded in writing and publications procedures are not taken. Neither it's relative nullity because it may be claimed by any interested party. The company is considered as if it had been created for the incapable person or partner whose consent was. During this period, the company keeps its legal personality if happen absolute, specific, and relative. During whatever any kind of nullity, company keeps legal personality and the profits distributed to the members will not be taken away from them. Finish elements, nullity, and in talking about dissolution of the company. When we talk about dissolution of the companies, it means finish or liquidate the assets, the money, the capital, all the relationship between members and partners. I have two kind of dissolution, general and specific cause of this. Now we are talking a dissolution or general causes of dissolution. Number one, dissolution by expiration of the term according Article 526, Para 1 of Civil Code, talking about a company is terminated by the expiration of its term as determined in the contract. And also, the original term stipulated by the contract, and on the other hand, that the agreement be made. And immunity or the majority of members stipulated and wanted to finish the term or to finish the formation of the contract or to delete the company. When the agreement or when company contract terminate about the time and the partners or members wants to review or renew, this is formation contract, it should to create a new company, a new contract. Termination of the undertaking. If a company has established for the performance of a certain act, it shall be dissolved by termination if the finish the project, if the finish undertaking. Okay? Although which the company was created, the contract shall be renewed for a period or another time. Loss of the company's assets. If happen like a fire, like any destroyed the company's assets, okay, in this case, termination the company. The loss. It could be moral, for example, if a company were created to exploit a certain privilege that was taken away from it at a later date. Like if the company making project at Egypt and finish and happen, destroy it or fire like that. In this case, termination the termination by agreement of members and also termination according judicial dissolution and if happen merge between partners with another company. Now we are talking specific causes of dissolution like withdrawal of a partner, withdrawal nevertheless restricted by two conditions, and death of a partner, and if happen insolvency, bankruptcy, or incapacity of any partner or member. Finally, if happen the company contract not publication, this is the cause of this dissolution. If not published, it becomes null, meaning the rights of third parties dealing with the company are not subject to these dissolutions. The partner remains liable for acts concluded in the company name even after dissolution. Thank you very much for listening. We'll meet you again for a new lecture at subject commercial law. Goodbye.